So for this segment, John and I wanted to talk with you about the ancillary documents that will accompany your revocable living trust. One of the very first things is a pour-over will. And I know we said that we're avoiding probate and the need for a will, but why do we need a pour-over will?
We always get the question, well, why do we need a will if we have a trust? And we're even guilty of saying, well, a trust is a will substitute, and then we give you a will as well. So it's a backup plan. We have been illustrating a revocable living trust as a box, an open box that's changeable. So think of the pour-over will. If you left an asset out of the trust and both of you have passed, then it pours the asset into the box where it follows your rules. Remember, the box, the open box, your rule book. So we're using analogies to describe. So the pour-over will is a backup will that does have to go through probate if any asset is subject to it. But a probate is much simpler if it's only for one asset.
This is often illustrated by property that you may have inherited from someone and you never got around to retitling it and putting it into your trust. Or I like to use the example of a winning lottery ticket that you didn't cash before you passed away, and that's certainly something that your family would want to use the pour-over will.
Yeah, or something that had the wrong beneficiary designation. Let's say an individual or the trust was not listed, and the company, the insurance company, the IRA company, the annuity company said the default was your estate. So we have to have the pour-over will because we don't want to be subject to, as Melanie said in an earlier segment, state law, because we're replacing state law with your wishes when you do a revocable living trust.
So you will notice your pour-over will is very short, and it's simply saying that if you pass away with something that must go through probate, that you are wanting the court to place it in your revocable living trust and be done with it as fast as possible. So all of the terms that are important are in your trust.
That's it.
And then, of course, we also have the assignment of personal property for the revocable living trust.
Yeah, so we talked earlier about a personal property memorandum that's referenced in your trust, and then what happens if you didn't list personal property on there, because that personal property memorandum is actually optional. So the assignment of personal property makes the trust the open box on your personal property, and that way the trustee follows your instructions to give it out. It's really that simple.
Right, and people always ask, how do I get my things, my stuff, into the trust? This is it. It's a one-page paragraph where we are saying your personal property, your things that cannot be retitled by a deed or other contractual means are placed inside your trust.
Mm-hmm. Yeah, that's the highly technical legal term of the day, stuff.
Stuff. You will also have state-specific financial powers of attorney and healthcare powers of attorney.
Yeah, so Melanie mentioned earlier about the trustee handling your incapacity. So if you and your spouse, or you if you're a single person, are incapacitated through a car wreck, God forbid an illness, the trustee takes over and manages the trust for your benefit. So the power of attorney, kind of like the pour-over will, is filling in a gap. Mm-hmm. So it's covering your incapacity for things that may not be in the trust, but may be pointed to the trust. So the trust may act on them when you've passed, but the ownership may not exactly be in the trust. So, and on, could be a bank account that we just got pointed to the trust, or an insurance policy that's not actually owned by the trust. Or IRAs, retirement plans, are great examples, because you can't transfer ownership of retirement plans because the IRS says that's going to trigger taxation. And so the power of attorney lets us avoid going to probate court while you're alive. So we never want to go to probate court while one of you are living, a husband and wife, or a single adult person. You don't want to put that burden on somebody to gain the authority to do whatever needs to be done.
And it can be offensive if it's a spouse or even if it's a parent and it's a younger adult that has an incapacity. The family feels very uncomfortable with the fact that a judge is telling them what they can and cannot do with property, and particularly if it's a spouse or a partner. We feel like we contributed to things, we are a team, and now we have a third party that's telling us what we can do. And we even have to ask permission of the court before we can make any actions. So this document takes care of that.
So that's a financial, general, durable power of attorney.
Now, also, we have the healthcare powers of attorney. And this is more than just the living will or the advanced health care directive. It's going into everything. Which doctor are we using? Which hospital are we going to? Do we want to be on this side of town or that side of town because we like the hospital better? Which surgery are we having? Which treatment?
Mm-hmm. So what you're doing is obviously you can't know those things in advance. So choice of decision maker, choice of trustee, choice of financial power of attorney, choice of healthcare decision maker is very personal. So we choose the person that is in the best position to handle that. So a lot of parents, a lot of adults doing their estate plan, they choose someone different than is doing their financial decision making, because a person may know more about healthcare, they may be more calm under pressure. They just may be more realistic. So you're choosing
the son that's a doctor, or the daughter that's a doctor, or the nurse, or
and the discretion is there, like Melanie said, to know what to tell the doctor or the hospital, the power to order pain relief, the power to speak for you when you can't speak for yourself. So we think that is almost one of the most important documents. That's while you're living, so your quality of life is arguably a more important topic than where your stuff goes when you pass away. So a healthcare power of attorney is a quality of life document, and it's, again, like all this is customizable, but the basic document, the plan, the basic healthcare plan is pretty thorough.
And it's designed to help family members, hopefully not to fight. So I can't tell you the times that I've had families call me from the hospital and they're having issues about who's going to make a decision. So this document can put someone in charge that possibly it takes the guilt off of other family members, or it just simply works to lessen the tension.